Welcome, dear students, to yet another lecture on family law. The topic of today's deliberation is irretrievable breakdown of marriage as a ground for divorce. The objectives of today's lecture are to understand the ground of irretrievable breakdown of marriage as a ground for divorce, to understand the historical background of irretrievable breakdown of marriage. Number 3, to understand the judicial approach to the problem. And lastly, we shall also understand the claim for a DNA test of a child. Dear students, the concept of sanctity of marriage is giving way to workability and practicality of harmonious relationship. The purpose of marriage is to give happiness to the parties and peace and harmony to all concerned. When this purpose is lost and the cumulative effect of the situation indicates that it is impossible for the parties to live happily together, the courts today are more inclined to give meaningful relief to the parties rather than to compel them to live together. Traditionally, the law of divorce was based on the fault theory. Under the fault theory, guilt has to be proved. Divorce courts are presented concrete instances of human behavior as to bring the institution of marriage into disrepute. A law of divorce based mainly on fault is inadequate to deal with a broken marriage. Once the marriage has broken down beyond repair, it would be unrealistic for the law not to take notice of that fact, and it would be harmful to society and injurious to the interest of the parties. Where there has been a long period of continuous separation, it may fairly be surmised that the matrimonial bond is beyond repair. The marriage becomes a fiction, though supported by a legal tie. By refusing to sever that tie, the law in such cases does not sever the sanctity of marriage. On the contrary, it shows scant regard for the feelings and emotion of the parties. Public interest demands not only that the marriage status should, as far as possible, as long as possible, and whenever possible, be maintained, but where a marriage has been wrecked beyond the hope of salvage, public interest lies in the recognition of that fact. Since there is no acceptable way in which a spouse can be compelled to resume life with the consort, nothing is gained by trying to keep the parties tied together forever to a marriage that has in fact ceased to exist. The breakdown theory of divorce, which is inherently attached with the no-fault theory of divorce, represents the modern view of divorce. Under this theory, the law realizes a situation and says to the unhappy couple, if you can satisfy the court that your marriage has broken down and that you desire to terminate a situation that has become intolerable, then your marriage shall be dissolved, whatever may be the cause. The marriage can be said to be broken when the objects of the marriage cannot be fulfilled. When there is not even an iota of hope that the parties can be reconciled, it can be considered as an irretrievable breakdown of marriage. Another logic why this theory holds is that after the marriage has ceased to exist in substance and in reality, there is no reason for denying divorce. Divorce should be seen as a solution and as an escape route out of a difficult situation. Such divorce is unconcerned with the wrongs of the past, but is concerned with bringing the parties and the children to terms with the new situation and developments by working out the most satisfactory basis upon which they may regulate their relationship in the changed circumstances. Legally speaking, irretrievable breakdown of marriage is defined as the situation that exists when either or both the spouses are no longer able or willing to live with each other, thereby destroying their husband and wife relationship with no hope of resumption of spousal duties. In other words, irretrievable breakdown of marriage can be defined as such failure in the matrimonial relationship or such circumstances adverse to that relationship that no reasonable probability remains of the spouses remaining together as husband and wife for mutual comfort and support. Some jurists have also expressed their view against irretrievable breakdown of marriage as a ground for grant of the degree of divorce. In their opinion, acceptance of irretrievable breakdown of marriage as a ground puts human ingenuity at a premium and throws wide open the doors to litigation and creates more problems than are sought to be solved. The other majority view, which is shared by most jurists, is that human life has a short span and situations causing misery cannot be allowed to continue indefinitely. A halt has to be called at some stage. Law cannot turn a blind eye to such situations, nor can it decline to give adequate response to the necessities arising therefrom. Now, dear students, we shall have a look at the historical background of irretrievable breakdown of marriage as a ground for divorce. The 71st report of the Law Commission of India briefly dealt with the concept of irretrievable breakdown of marriage as a ground for divorce. This report was submitted to the Government of India on the 7th of April 1978. In this report, it was mentioned that a very important question that has engaged the attention of lawyers, social scientists, and men of affairs is: should the grant of divorce be based on the fault of the party, or should it be based on the breakdown of the marriage? The former is known as the matrimonial offence theory or the fault theory. The latter has come to be known as the breakdown theory. As per the report of the Law Commission of India, in 1920, New Zealand became the first of the Commonwealth countries to introduce that a separation agreement of 3 or more years could become a ground to file divorce before the courts. The New Zealand Divorce and Matrimonial Causes Amendment Act 1920 included for the first time the provision that a separation agreement for 3 years or more was a ground for making a petition to the court for divorce, and the court was given a discretion without guidelines whether to grant the divorce or not. The discretion conferred by this statute was exercised in a case in New Zealand reported in 1921. The Law Commission said that the objectives of any divorce law are twofold. I quote, 1. To buttress rather than undermine the stability of marriage, and 2. When regrettably a marriage has irretrievably broken down, to enable the empty shell to be destroyed with the maximum fairness and minimum bitterness, distress and humiliation. Unquote. Thus, if a marriage has broken down beyond all possibilities of repair, then it should be brought to an end without looking into the causes of the breakdown and without fixing any responsibility on either party. In the report, it is mentioned that restricting the ground of divorce to a particular offence or matrimonial disability causes injustice in those cases where the situation is such that, although none of the parties is at fault, or the fault is of such a nature that the parties to the marriage do not want to divulge it, yet there has arisen a situation in which the marriage cannot be worked. The marriage has all the external appearances of marriage, but none of the reality. As is often put pithily, the marriage is merely the shell out of which the substance is gone. In such circumstances, it is stated that there is hardly any utility in maintaining the marriage as a facade, when the emotional and other bonds which are of the essence of marriage have disappeared. It is also mentioned in the report that in case the marriage has ceased to exist in substance and in reality, there is no reason for denying divorce. Then the parties alone can decide whether their mutual relationship provides the fulfillment which they seek. Divorce should be seen as a solution and as an escape route out of a difficult situation. Such divorce is unconcerned with the wrongs of the past, but is concerned with bringing the parties and the children to terms with the new situation and developments by working out the most satisfactory basis upon which they may regulate their relationship in the changed circumstances. On May 22, 1969, the General Assembly of the Church of Scotland accepted the report of their Moral and Social Welfare Board, which suggested the substitution of breakdown in place of matrimonial offences. It would be interesting to quote what they said in their proposals. I quote, "Matrimonial offences are often the outcome rather than the cause of a deteriorating marriage. An accusatorial principle of divorce tends to encourage matrimonial offences, increase bitterness and widen the rift that is already there. Separation for a continuous period of at least 2 years, consequent upon a decision of at least one of the parties not to live with the other, should act as a sole evidence of marriage breakdown. Once the parties have separated and the separation has continued for a sufficient length of time and one of them has presented a petition for divorce, it can well be presumed that the marriage has broken down. The court, no doubt, should seriously make an endeavour to reconcile the parties. Yet, if it is found that the breakdown is irreparable, then divorce should not be withheld. The consequences of preservation in law of the unworkable marriage which has long ceased to be effective are bound to be a greater source of misery for the parties. In Hindu law, the breakdown theory has its own version. Under Section 13A of the Hindu Marriage Act 1955, divorce can be obtained by either party to a valid marriage on the following grounds. A. If it is shown that a decree of restitution of conjugal rights has not been complied with for a period of 1 year or more. B. If it is shown that cohabitation has not been resumed for a period of 1 year or more after the passing of the decree for judicial separation. Now, dear students, we shall look at the approach of the judiciary to the irretrievable breakdown of marriage as a ground for divorce. In Madhukar versus Saral, the Bombay High Court held that the enactment of Section 13, Clause 1A in 1964 is a legislative recognition of the principle that in the interest of society, if there has been a breakdown of the marriage, there is no purpose in keeping the parties tied down to each other. In Abu Bakr Haji versus Manu Koya, the Kerala High Court held that trivial differences get dissolved in course of time and may be treated as teething troubles of early matrimonial adjustment. The stream of life lived in married mutuality washes away smaller pebbles, but that is not the case when the incompatibility of minds breaks up the flow of the stream. In such circumstances, the breakdown of marriage is evident, so we recognize that fact and accord divorce. Again, the Delhi High Court observed in Ramkali versus Gopal Das that it would not be a practical and a realistic approach indeed. It would be unreasonable and inhuman to compel the parties to keep up the face of marriage even though the rift between them is completed and there are no prospects of their ever living together as husband and wife. In Harendranath Burman versus Suparva Burman, the court observed that the mere breakdown of marriage, however irretrievable, is not by itself and without more any ground for the dissolution of the marriage as yet under the matrimonial law. Where the parties were living separately for 16 years without any chance of reconciliation, the court held that the marriage had broken down and dissolution of marriage was justified. It may be noted that in this case the term irretrievable breakdown has not been used, only broken down has been used. But lately, even the apex court is using the phrase irretrievable breakdown of marriage. In Gajendra versus Madhumati, it was held that where the parties have been living separately for 17 years, the chance of their reunion may be ruled out, and it may be reasonable to assume that the marriage has broken down irretrievably. So the marriage should be dissolved. In the case of Chetan Das versus Kamala Devi, the husband petitioned for divorce on the ground of the wife's desertion. The wife, in her written statement, alleged the husband's adultery. The husband's allegation of objectionable behavior of the wife consisted of a meek plea that the wife was dissatisfied with the living conditions at the husband's place, and so she wanted him to live with her at her parents' house. It was also pleaded that the marriage had irretrievably broken down. The court found the wife's allegations of husband's adultery to be true. In such circumstances, the court held that the right of divorce could not be granted merely on the ground that the marriage had broken down, and the husband who committed the wrong, that is, living an adulterous life, could not be given advantage of his own wrong on the ground of wife's alleged desertion. The wife was still prepared to join him if he mended his ways. The court observed, and I quote, "The institution of marriage occupies an important place and role in society. Therefore, it is not appropriate to apply any submission of irretrievably broken down marriage as a straitjacket formula for grant of relief or divorce. This aspect has to be considered in the background of the facts and circumstances of the case." Unquote. In Sandhya Rani versus Kalyan Ram Narayan, the Supreme Court reiterated and took the view that since the parties were living separately for the last more than 3 years, there was no doubt that the marriage between the parties had irretrievably broken down. There was no chance whatsoever of their coming together. Therefore, the court granted the decree of divorce. In the case of Chandrakala Menon versus Vipin Menon, the parties had been living separately for many years. The court came to the conclusion that there was no scope of settlement between them because, according to the observation of the court, the marriage had irretrievably broken down and there was no chance of their coming together. The court granted the decree of divorce. In the case of Kanchan Devi versus Pramod Kumar Mittal, the parties were living separately for more than 10 years, and the court came to the conclusion that the marriage between the parties had to be irretrievably broken down and there was no possibility of reconciliation, and therefore the court directed that the marriage between the parties should dissolve by a decree of divorce. In Swati Verma versus Rajan Verma, a large number of criminal cases had been filed by the petitioner against the respondent. The court observed that the marriage between the parties had broken down irretrievably with a view to restore the good relationship and to put a quietus to all litigations between the parties and not to leave any room for future litigation so that they would live peacefully thereafter, and on the request of the parties in exercise of the power vested in the Supreme Court under Article 142 of the Constitution of India, the court allowed the application for divorce by mutual consent filed before it under Section 13B of the Hindu Marriage Act and declared the marriage dissolved and granted decree of divorce by mutual consent. In Prakash Chand Sharma versus Vimlesh, the wife expressed her will to go and live with the husband, notwithstanding the presence of the other woman, but the husband was not in a position to agree, presumably because he had changed his position by remarriage. Be that as it may, a reconciliation was not possible. In V. Bhagat versus D. Bhagat, the Supreme Court, while allowing the marriage to dissolve on the ground of mental cruelty and in view of the irretrievable breakdown of marriage and the peculiar circumstances of the case, held that the allegations of adultery against the wife were not proved, thereby vindicating her honor and character. The court, while exploring the other alternative, observed that the divorce petition had been pending for more than 8 years and a good part of the lives of both the parties had been consumed in litigation, and yet the end was not in sight, and that the allegations made against each other in the petition and the counter by the parties would go to show that living together was out of question and rapprochement was not in the realm of possibility. The court, after granting a decree of divorce, observed in the concluding part of the judgment that, I quote, "Before parting with this case, we think it is necessary to append a clarification. Merely because there are allegations and counter-allegations, a decree of divorce cannot follow. Nor is mere delay in disposal of the divorce proceedings by itself a ground. There must be really some extraordinary features to warrant the grant of divorce on the basis, after obtaining a decree of divorce, of pleading and other admitted material without a full trial. Irretrievable breakdown of marriage is not a ground by itself, but while scrutinizing the evidence on record to determine whether the grounds alleged are made out, and in determining the relief to be granted, the said circumstance can certainly be borne in mind. The court observed that the unusual step, as the one taken by the court in this instant case, can be resorted to only to clear up an insoluble mess when the court finds it in the interest of both the parties. In Durga P. Tripathi versus Arundhati Tripathi, the Supreme Court further observed that marriages are made in heaven. Both parties have crossed the point of no return. A workable solution is certainly not possible. Parties cannot, at this stage, reconcile themselves and live together, forgetting their past as a bad dream. Therefore, the court held that it had no other option except to allow the appeal and set aside the judgment of the High Court and affirm the order of the Family Court by granting a decree for divorce. In Lalita versus Manik Swami, the court cautioned that the unusual step of granting the divorce was being taken only to clear up the insoluble mess when the court finds it in the interest of both the parties. In the case of Naveen Kohli versus Neelu Kohli, the Supreme Court of India made a strong plea to the Union of India for incorporating irretrievable breakdown of the marriage as a separate ground for divorce under Section 13 of the Hindu Marriage Act 1955 and amending the Hindu Marriage Act accordingly. It further observed, I quote, "The foundation of a strong marriage is tolerance, adjustment, and respecting one another. Tolerance to each other's faults to a certain bearable extent has to be inherent in every marriage. Petty quibbles, trifling differences should not be exaggerated and magnified to destroy what is said to have been made in heaven. All quarrels must be weighed from that point of view in determining what constitutes cruelty in each particular case, and as noted above, always keeping in view the physical and mental condition of the parties, their character and social status. A too technical and hypersensitive approach would prove counterproductive to the institution of marriage. The courts do not have to deal with ideal husbands and ideal wives. It has to deal with a particular man and a woman before it. The ideal couple or a mere ideal one will probably have no occasion to go to the matrimonial court. To conclude, the trend is increasingly in favor of the inclusion of irretrievable breakdown of marriage as a ground for divorce. Nevertheless, in Hindu law, the breakdown theory has its own version. Under Section 13A of the Hindu Marriage Act 1955, divorce can be obtained by either party to a valid marriage on the following grounds. Number 1, if it is shown that a decree of restitution of conjugal rights has not been complied with for a period of 1 year or more. B, if it is shown that cohabitation has not been resumed for a period of 1 year or more after passing of the decree for judicial separation. Now, dear students, we shall discuss adultery as a ground for divorce and the plea for the DNA test on the child. For a matrimonial offence that usually takes place secretly, in the absence of the other spouse, sometimes randomly and at other times in a planned manner, to bring in the direct proof of the paternity of the child is virtually next to impossible. With the advancement in scientific technologies, a person having strong reasons to believe in the infidelity of the spouse, leading to, in his perception of fathering somebody else's child, would normally be a nightmarish trauma that can now be authenticating by confirming it. In the past, the courts have always adopted a protectionist attitude towards ordering or subjecting a party to the DNA test for the fear of what they term as bastardizing an innocent child. Therefore, unless and until the husband convinces the court of no access to the wife at the time of possible conception of the child, the court would not order the child to undergo a DNA test. If he fails to convince of non-access, the court would apply presumption of paternity under Section 112 of the Indian Evidence Act. In a case before the Madras High Court, that is in Puniyappan versus Poni, the husband, a contractual labourer at Bangalore, filed a petition praying for a decree of divorce under Section 13 of the Hindu Marriage Act. Pending this petition, he also filed an application under Section 112 of the Indian Evidence Act, praying to the court to direct the blood test to be conducted upon the second son of the wife to find out its biological father, as he suspected his paternity. The wife was residing at her parents' place in Madipala village all along, and he was working at Bangalore. He had not visited her at the time of possible conception of the child or any time near it. As such, he suspected that the wife was having an affair with another person and was continuing the same. The wife disputed the claims of the husband and contended that it is a settled position that DNA tests cannot be ordered as routine in all the cases. As she was a married woman, the presumption of paternity cannot be disputed. An order of DNA test would amount to a violation of her rights of privacy, and that the husband's sole objective in disputing the paternity of the child was to tarnish her image. The husband, on the other hand, contended, firstly, that in exceptional cases, and his was one such exceptional case, a DNA test can be ordered, and secondly, as per the requirements of Section 112 of the Indian Evidence Act, he had established non-access and made out a prima facie case. The High Court observed that a well-settled principle in this connection is that a matrimonial court has the power to order a person to undergo a medical test, and passing such an order by the court would not be in violation of the right to personal liberty under Article 21 of the Constitution. But the court should exercise such power if the applicant has a strong prima facie case and there is sufficient material before the court. If, despite the court's order, the respondent refuses to submit himself or herself to medical examination, the court would be entitled to draw an adverse inference against him or her. It quoted some important earlier judicial pronouncements, that is Kamti Devi versus Poshiram, wherein it was held that the conclusiveness of the presumption under Section 112 of the Indian Evidence Act cannot be rebutted by the DNA test, and proof of non-access to each other is the only way to rebut that presumption. The Apex Court in the past, in the case of Gautam Kundu versus State of West Bengal, had issued specific directions in this connection that were as: number 1, that the courts in India cannot order blood tests as a matter of course. Number 2, wherever applications are made for such prayers, in order to have a rowing inquiry, the prayer for having blood tests cannot be entertained. Number 3, there must be a strong prima facie case in that the husband must establish non-access in order to dispel the presumption arising under Section 112 of the Indian Evidence Act. Number 4, the court must carefully examine as to what would be the consequences of ordering blood tests, whether it will have the effect of branding a child as a bastard and the mother an unchaste woman. And number 5, no one can be compelled to give a sample of the blood for analysis. In the instant case, the court held that the husband was successful in proving prima facie a case of non-excess and that there was no harm in ordering of the DNA test, and the same would not be violative of the constitutional rights of privacy guaranteed to the wife as an individual. Though the pronouncement was appropriate in the light of the facts and circumstances of the case, but otherwise the hesitation of the courts in ordering for a DNA test for fear of it having an adverse impact on the child appears to be misplaced. Societal imposition of stigma and its adverse impact on the child is now an outdated concept. Present times recognize the right of a child to know who his real father is with the help of a DNA test, and the same is being entertained by courts in India. The child's first and intimate interaction is with the parents, and what is perhaps of utmost importance for the child is their undiluted love and affection. Where the father suspects the paternity of the child and he has strong reasons to believe it, but they are short of non-excess, it would be in the best interest of the child to have a conclusive determination of who his father is. Dear students, that was all about today's lecture on irretrievable breakdown of marriage as a ground for divorce. Hope you have understood it well. We shall meet again with a new topic. Till then, take care of yourself. Goodbye.